any law that is passed by the Parliament does not come into effect till the rules spell out how the law is to be implemented. This was also the case with the data protection law that was passed by the Parliament in August of 2023. That's why rules were eagerly awaited. Today, after a wait of a little over 2 years, the government notified the data protection rules. So what exactly do these rules say? Well, the data protection law completely changes the way companies do business in the digital age. So to allow for migration to a new regime, the rules provide a staggered implementation timeline. As the first step, the rules for setting up the Data Protection Board have come into effect immediately. The board will act as a data watchdog. The government can now begin with appointing the chairperson and members of the board. Step 2 provides for a 12-month window for bringing in consent managers. The law introduced the concept of consent managers to help you give, manage and review consent. Step 3 gives the industries and government entities 18 months to become compliant with data protection law. All entities collecting data have this period to ensure that consent mechanisms are in place along with other operational requirements. Next, the industry has been watching very carefully for government stance on data localization. Under the new rules, companies can move personal data of users to servers outside the country, but as per government regulations. But as far as big tech is concerned, the rules are a little different. Under the latest rules, a government committee is authorized to restrict certain data sets from being transferred to servers overseas. And speaking of big tech, they have additional compliances as well. It is mandatory for them to conduct data protection impact assessment and compliance audits. They are also required to ensure that algorithms that they use are not likely to cause any user harm. This, of course, is over and above the earlier overhang of a committee suddenly deciding if certain data sets have to be stored only within the country. And speaking of users such as us, companies collecting data will need to issue a consent notice in clear and simple language. The notice must clarify what data is being asked for and the purpose of seeking that information. All such companies will also need to have a dedicated link where users can go to withdraw their consent. For minors, companies will have to ensure verifiable consent from parents or guardians. In case of data breach, the companies are expected to inform users at the earliest. The companies need to inform the nature of the breach, what it means for the users, and the recommended safety measures. The details of the breach also need to be shared with the Data Protection Board within 72 hours. The rules also give wide powers to the government. It can seek personal data from any entity collecting data in case of national security. It can also restrain that entity from informing the user that the government has asked for such information. But even with the rules coming in, some stakeholders are still asking questions. Are AI companies exempt from the data protection rules? What about data already collected? And finally, why no exemption for journalists? Clearly questions that industry, stakeholders, academics, think tanks will now be posing to the government.
Hey, thank you for watching this on CNBC TV18. Hope you liked it. For more such interesting news and updates, follow CNBC TV18 on all the social media platforms.